For many international families, a trust is used to centralize control. The trust can hold assets, define how decisions are made, and create continuity beyond the lifetime of the founder. My name is Shiraz Wahid and I'm the co-founder at Lepidus Wealth. And in this video, I'm going to explain the difference between Hong Kong Trust and Singapore Trust, how each jurisdiction is usually used, where they differ, and how families should think about choosing between them for the purpose of estate planning, asset protection, and long-term succession. Neither Hong Kong nor Singapore should be viewed as a secrecy-based offshore jurisdiction. Both are established, regulated, and internationally connected common law centers. The decision is usually about governance, tax coordination, banking access, and long-term control. A family trust is a legal arrangement where assets are transferred to the trustee who holds and manages those assets for selected beneficiaries. The person who creates the trust is usually called the settlor. The trustee administers the trust according to the trust deed, which acts as the rulebook for the structure. For family wealth, a trust is usually used for succession, control, and asset protection. Succession means assets can continue within a structured arrangement instead of passing only through personal ownership or probate. Now, control means that the family can separate economic benefit from direct legal ownership. Asset protection depends on timing, solvency, intent, and the laws involved. A trust created early for proper reasons may create separation between personal ownership and trust assets. But a trust created after a claim that has already been made should not be treated as a simple protection tool. Now, coming to the topic, Hong Kong has a long common law tradition and is widely used by families with assets, businesses, or investment exposure connected to the Greater China and North Asia region. For families with operating businesses in Hong Kong, China-linked holding companies, regional investment accounts, or professional advisors based in Hong Kong, a Hong Kong trust can feel more commercially aligned. The legal system is familiar to many international banks, trustees, and advisors. Many founders use Hong Kong structures thinking not only about investment portfolio, but also about company shares, family businesses, pre-IPO holdings, or succession of control across generation. Hong Kong also allows modern trust planning features, including the ability for a settlor to reserve certain powers. This can usually be useful where a founder is not ready to give up all the influence immediately. These powers may include investment-related decisions or other powers allowing under the trust deed. Reserve powers must be drafted carefully. If the settlor keeps too much control, the trust may be challenged in some circumstances or treated differently for tax or legal purposes in other jurisdictions. Now, Singapore is also a common law jurisdiction, and it has become one of the most recognized private wealth center in Asia. It is often used by international families who want a stable, regulated, and internationally respected jurisdiction for wealth holding, succession, and family office planning. Singapore is especially attractive where the family wants a broader international wealth platform. Many families use Singapore not only for trust, but also for investment management, family office setup, private banking, and regional holding structures. The trustee industry is highly regulated in Singapore, and trust companies carrying out trust business generally fall under a formal trust company framework. This gives many families comfort because the jurisdiction has a clear licensing and supervision environment. Singapore can also be useful for international succession planning. Its trust laws includes provisions that may help reduce the impact of foreign forced heirship claims in certain situations. Forced heirship means laws in some countries that require part of a person's estate to pass to specific family members regardless of what the will or trust says. This does not mean a Singapore trust overrides every foreign law in every case. The family's domicile, tax residency, asset location, and beneficiary location still matter. Now, Hong Kong and Singapore are often compared because both are serious Asian wealth centers. Both are based on common law and both are used by international families. Both jurisdictions are recognized by banks, trustees, professional advisors as well. And in both jurisdictions, a trust can help move assets away from direct personal ownership into a managed legal structure. This can support probate planning, continuity, beneficiary protection, and long-term governance. Both jurisdictions also support reserve power, although the exact drafting and legal consequences needs careful review. Now, many founders need continuity, but they also want a controlled transition rather than an immediate loss of influence. Both Hong Kong and Singapore can be used with underlying companies. For example, a trust may own shares in a holding company, and that holding company may own investment assets, business shares, or other family wealth. The tax coordination remains important. A trust may be established in Hong Kong or Singapore, but the tax result can depend on where the settlor is resident, where beneficiaries live, and where assets are located, as well as whether any distributions are made or not. Domicile, residency, asset status, and beneficiary positions must all be reviewed together carefully. The practical difference between Hong Kong and Singapore often starts with the family center of gravity. If the family's business life is closer to Hong Kong, mainland China, North Asia, then Hong Kong may be easier to align with existing relationships. The family may already have corporate structures, bank accounts, advisors, and legal documents connected to Hong Kong. However, However, if the family is more internationally diversified or wants a broader family office and investment platform, Singapore may be more suitable. Singapore is often used where the family wants private banking, investment management, trust administration, and family office governance in one coordinated environment. Now, regulation is another difference. Singapore's trust company framework is often viewed as more formalized from a licensing perspective. This can be attractive for families who want a regulated trustee environment and institutional administration. The trustee relationship is also important. A trust is only as effective as the people administering it. Families should compare not only the jurisdiction, but also the trustee's experience, reporting style, investment approach, responsiveness, fee structure, and the ability to work with advisors in other countries. For wealthy families, governance is often more important than the jurisdiction itself. Governance means how decisions are made, who has the authority, who must be consulted, and how conflicts are resolved. A well-designed trust should explain the role of the trustee, the powers of any protector, the rights of the beneficiaries, and the process for distribution, as well as how investment decisions are made. A trust may also connect with other structures. It may own holding companies, a foundation, or an SPV in other jurisdictions for certain family and governance requirements. Wills, on the other hand, may still be needed for assets that are outside of the trust. SPVs may be used to separate different asset classes. Now, if you ask the question, which jurisdiction is better, there is no single answer that applies to every family. Hong Kong may be better where the family has strong Hong Kong, China, or North Asia connections, where assets are already administered through Hong Kong, or where the family wants the trust close to its commercial structure. Singapore may be better where the family wants a private wealth platform, regulated trustee administration, family office coordination, and strong international banking access. For some families, the answer may involve that neither of the jurisdiction is their main structure, and other offshore jurisdictions such as a UAE foundation, a Jersey trust, or a Cayman structure may fit better depending on their assets, tax position, and family objectives. The right structure starts with a family map, where the assets are, where the beneficiaries are, where the settler is resident and domiciled, where are the companies incorporated, and where are the bank accounts held, which countries may tax the trust or its distribution. Once those points are clear, the choice becomes more practical. The trust jurisdiction should support the family's real life, not just look attractive on paper. A Hong Kong trust and a Singapore trust can both be strong tools for estate planning, succession, and wealth preservation. The better choice depends on connections, control, the trustee quality, tax coordination, and how the structure fits within the family's wider planning. So if you want our help and would like to explore whether a Hong Kong or a Singapore trust structure fits your needs the best, you can request a personalized asset protection plan by clicking the link in the description below. That's it for today, and I will see you in the next video.